Hello, everyone. Welcome, as always, to the Thursday afternoon webinar from Hines Legal. As always, I'm Chris Hines, Strata Advisor. I'm going to be in the hot seat today, and joining us, special guest, Airlie Maclachlan, CEO, Hines Legal. Airlie, welcome.
Thanks, Chris. It's nice to find you in this particular format for a change.
Thank you. I'm sure everyone is wondering, where is Frank? Frank is off at important client meetings. That is not code for anything. He really is off at important client meetings. He sends his best and he looks forward to being back in the webinars in due course. Just a quick reminder to everyone, please like and share. If you like and share, the wider it goes, the more chance we have of setting up topics and format and answering questions the best way that we know how, and it's also most responsive to all of you as well. Today, slightly different approach. Airlie is going to grill me on what it means to be a body corporate commissioner. Before we do that though, I might ask you, Airlie. Airlie, how does one get to be a CEO of a law firm?
Chris, I think sometimes that might be more by accident than by design. Probably a long business background and somehow a level of expertise that ends up being in the law. So, yeah, certainly not by design, but with Hines now, after a long background or a long period of time working for other law firms. So a good place to be.
Yeah, and it's actually a really nice segue into the topic, because one does not grow up wanting to be the body corporate commissioner, but it just kind of happens more than anything. Yeah, and yeah, there is literally only one of its kind in the world. So over to you, Airlie. I mean, what?
It's a very curious thing, Chris, because for me, trying to understand what it is that you do or did, I've had to go and have a look at this curious thing called the Body Corporate Commissioner's Office, which you did head up, I think, for 5.5 years, if I'm correct. And it still, to me, remains a bit of a mystery as to really what goes on in it day by day. I think I pick up another little tip as to how it actually works. So it'll be fun today to be able to help everybody understand a little bit more about it. Nice to be able to quiz you in a friendly way and maybe let's see if we can get to some difficult topics a little later on. Thought we might start with some stuff that's pretty vanilla, maybe, and ask you, what actually does it do?
Oh, gosh. Well, two main things it does. It gives out information and it resolves disputes, and that takes on a whole heap of different meanings. But the better way to think of it maybe is what it doesn't do. So it doesn't take complaints, for example. So it's not like fair trading or ACCC where you ring up and you say, I didn't get my refund. It doesn't operate like that. Nor is there a fleet of body corporate inspectors or body corporate police out there. So it's not as though you can file a complaint and then someone will go and do a compliance check of your body corporate and then issue a ticket. It's the other way around. It's you come to the commissioner, you either have a problem or you seek some information. The commissioner's office is tasked with the job of doing one of those two things effectively. But unless you do it, unless you initiate it, you don't get anything. That doesn't sound too blunt, does it?
No, it doesn't sound too blunt. How many people in the team?
30 all up.
And those 30 service all of Queensland. That's right. Is that right?
Yep.
That seems to be, from my perspective, not very many people for quite a large job.
No, it's not. That's 30 people for potentially every scheme in Queensland, and there are 50,000 of those. And if you want to extrapolate that to the number of people who live in an apartment, that we're looking at probably 1 million or so. So it's not a lot of people, no. And I look, that office does an amazing job with the resources it has. And I think, not to steal any of your thunder, Airlie, one of the reasons why it's relatively small is that it's so niche. and therefore it flies under the radar. So think of it this way. I'm the Attorney General. I've got responsibility for a whole bunch of things. One of those things just so happens to be body corporate services. I know I've got this mysterious little boutique called the Commissioner's Office. I know they do stuff, but it's not forefront of mind. Therefore, if you're not forefront of mind, it's always harder to be open and get those resources to grow, if you like.
Okay, is there any talk about increasing the number of people within the office?
What I would say there is that it's got to be paid for somehow. The way government tends to work is that if you want something, you've got to come up with the model to pay for it. And one of them, invariably, the model would have to come back to the individual owners. So often I've had people come to me and propose some kind of levy or some kind of subsidy on titles office registrations, with a proportion of that going off to fund the Commissioner's Office. There's a model that works kind of like that in South Africa. In fact, there's a titles ombudsman working on that model with a percentage siphoned off to support them. Very similar to the Residential Tenancies Authority model in Queensland.
Okay.
Money from bond funds that agency. There has to be a will to do that. There's a lot more that could be done with a lot more resources. A lot more people could be reached. We'd do ourselves out of a job though, Airlie, I suppose.
Let's not go there quickly then. The Chris, so what happens if I've just got a question? What happens if I ring you with a question?
So there's a 1-800 number and anybody can ring that at any time, and then one of the operators talks you through invariably your question. It's very rare that a body corporate question has a yes/no answer, and it's even more rare that the body corporate question would have a simple 3-minute discussion. I think the average call time at that office was, when I left, about 6 minutes, give or take 6 or 7 minutes. So say, for example, Airlie, you're a first-time caller, you own an apartment, you know that something's going on that doesn't sit right with you, there's a problem, you've had some conflict, you're not sure what this thing means or that thing means, and you want some information. So you call up and the staff there will talk with you a little bit about some basics, and the way it typically works is that they'll talk to you and then send you on your way and say, okay, go and get this information, go and do this research. Once you've gathered those pieces of information together, come back, and then we'll try it again. Oftentimes, it would take 3 calls of that nature before someone was equipped to be able to go away and handle something themselves. So that's how it would happen. Sometimes, a bit rarer, it would be that the call would come through and it'd be a very long conversation, and that would automatically trigger another process. But generally speaking, it's a bit of a staged step-by-step. Importantly though, Airlie, it's only information. There's no legal advice. There's no opinion given. There's no...
Why is that, Chris?
We're just protecting ourselves. We don't want people to say the Commissioner's Office told me to do this and then to find out it was wrong, because people do that. It used to happen all the time. People would say that I called the Commissioner's Office and they told me this, therefore I did this. I hear it. We hear it now here at Hines all the time. We get body corporate managers who come to us and say, I've had a client tell us the Commissioner's staff said this. Is that right? Invariably, they've got the wrong end of the stick, but with those staff in the Commissioner's Office have to be so careful that they keep it straight down the line. But they're only human, and invariably, there's going to be a situation arise where either the line is crossed or somebody misinterprets it and goes off on a folly. And that's when things can get very problematic.
Do you think it's appropriate to have both the information service and the dispute resolution side of the office sitting side by side? Should there be some sort of separation of powers in there?
Look, it works, but should it is a good question. I once did a conference where a legal practitioner not from Queensland, another state, had a real go at me about the fact that those two services were together and was adamant that was entirely inappropriate. For everyone watching and listening, the best model I can give you is this. If you had a matter to go to the magistrate's court, for example, there's no 1-800 helpline for the magistrate's court that you ring where the magistrate's court staff give you information about magistrate's court processes and what options you have. The most they'd tell you is it's form number this, and this is the fee, and here's the location of the court. That's it. Whereas this office does both things. It resolves the matter, but it also gives the information in the first place. And the model, Airlie, is basically if that first level, the information works really well, it won't need the second. That's the model. And that's why government has put it together that way. Should it be together? Well, I don't know. What do you think? I mean, as the kind of the layperson looking in on that, well, I mean, how do you think that sits?
Because I think it can work. I think it just depends on those glass walls that sit almost within an individual. Can I be clean around this? Let's travel to something a bit more sort of formal. I'm sitting here. My questions are answered. I now know that I'm going to lodge an application. I fire that in. What happens when it hits your desk?
So you are applying to have your dispute resolved, and it's a service. So it is literally a service. So your application, all it does is it gets you in front of someone. Then the real fun starts after that. There is what's called a case management process where the staff vet the application. And when I say vet, they vet it incredibly robustly. Again, to make sure that the process, there's a few reasons why that happens that way, but one of the reasons is that this office is so unique. You're dealing with people's homes, you're dealing with people who might be on low incomes, low and fixed incomes. You're also dealing in a lot of cases with people who present with some kind of mental illness or some other disability. It's not appropriate, in my view, to send those people away and say, go and get legal advice. You have to provide some assistance to people who need it. But once it gets to that point where you've applied to have the matter resolved, the case manager vets it, and that goes right from the basics. Is it signed? Has the fee been paid? Right up to the more complicated questions. Is this in jurisdiction? Have you actually provided evidence to support the outcome that you're seeking? And then what happens is that those case managers actually call the applicant and say, we've got your application, there are problems with it. Here are the problems. Page 1, page 2, section 3, section 4. Those conversations can be very, very difficult and very, very time consuming because people put in an application thinking, well, I've put in my application, now I just want my outcome. That's what I want. And I'm in the right here. So again, coming back to you, Airlie, you know something's gone wrong with your apartment and your body corporate. All you want is to have it resolved. You don't care about fairness and process and natural justice. You just want it done. And so you've applied to my office with the fancy title. And it's like, well, why am I being asked all these questions? Why do I need to do all of this sort of stuff? And the answer is, it's your application. You need to run it. That can be a very confronting realization for a person. Yeah.
I bet. Chris, once I've sent it in, how long does this thing sort of take?
Well,
how long is a piece of string?
How long is a piece of string? One of two things happen. You either go off to conciliation, which is the informal method of resolving the dispute, and it actually works really well. About 3/4 of disputes when I left were getting solved at conciliation, and that's great. It's like you don't have endless argy-bargy. You actually have people sitting down with each other, talking about the problem, and then agreeing on a solution. So conciliation will happen first in about 95% of all cases. Conciliation can happen in 2 months, maybe 6 weeks, 2 months. And that will happen at the moment anyway, electronically. I don't think there's any face-to-face happening at the moment. There may well be some starting up. And then the other method is adjudication, which is where the quasi-judicial officer makes a binding order. That can take up to 6 months for the order, longer in some cases. There are some orders that get made much more quickly than that. There are emergency orders that can get made, and they can be done in a day or less. Then there are other orders which are injunctive, so putting a stop to proceedings. So really good example of that, come back to you, Airlie. You are an owner, the body corporate has resolved to do some works. You are concerned that those works are going to impact upon you, blocking your driveway. You don't agree with the decision that's been made, but if the work goes ahead, it's irreversible. So you can apply for a form of injunctive relief to put a hold on it and stop it while the substantive issue gets resolved. That injunctive relief can happen in a matter of days, and the longer substantive issue takes a lot longer after that. So
quick.
Can be quick, but the majority of them, no, it's literally a matter of months and a long, long time. And you don't hear anything about it because it's all done on paper. It's a paper-based thing. There's no hearings, there's no oral discussions or arguments or anything like that. So you put in your application and then you wait for the outcome.
Sometimes in our office, or sometimes we've had some results or seen some results that appear to be different. So what might appear to be a similar sort of matter, but with a different outcome. Is there an onus on adjudicators to be consistent?
Consistent, yes. Precedent, not really. No. It's a bit different to the courts in that the adjudicators aren't bound per se by other adjudicators' outcomes, but there is the expectation of consistency. And I think when I was in the chair, and I don't want to speak for the new commissioner, but I'm pretty sure she'd say the same thing, Airlie. Consistency is everything in this jurisdiction. You don't want one thing being told to one client one day and then another client presenting with virtually the same issue the next day being told to do something different. For starters, that's going to be hugely inconvenient, but it actually wrecks the credibility of the Commissioner's office after that, and that's actually paramount. So if you're saying that, if government is saying we want a credible voice in the sector to be the independent arbiter, to be the impartial body that's there to help out, then that body's got to work at achieving credibility. So, and the way to do that, there are many ways to do that. Good service delivery outcomes for a start, professional outcomes is another, thoroughness, attention to detail, but the one thing above all others is consistency. Having said all of that, you can have two disputes that look on paper to be identical about the same topic, and you can get two different outcomes. And why is that? Because every building is different. Therefore, the potential for every order is different, but it's very frustrating, I know. And I suppose the other thing, we need to talk about the human element to this, Airlie. Adjudicators are not robots. No, they're human, and like any other human decision maker, a lot of factors come to bear on them.
Absolutely. Chris, do you need lawyers in there?
Yeah, you do. Pretty much all of the adjudicators are legal practitioners. I think maybe one or two are not, but they have a background which is very closely aligned. I think, be it accounting or business, for example. We have a couple of other lawyers in different, I used to have a couple of other lawyers in different roles in the office. What is interesting is that for a number of the other staff in the office, they have backgrounds that you wouldn't immediately think lend itself to that work. And yet, when you step back and think about it, they actually do. I'm talking here about teaching background, psychology background, and there's one other that just escapes me at the moment. Yeah, but it's about process, Airlie. It's about step by step by rigorous process. And those professions which are all about rigorous attention to detail and analysis are perfect for working in the Commissioner's office. So you can think of many different backgrounds which would work there, I think. It's a very diverse office, very diverse.
I bet. I bet it is. Chris, and I guess the other side of that is how many applications come through with a legally trained rep on the other side?
When I
Not on the other
left,
side, application.
yeah, when I left, about a third, and that's a lot. So again, you cast your mind back. I don't think government ever intended that this is how the Commissioner's Office would be. All of the body corporate legislation is drafted around volunteers resolving and managing things themselves. The reality is very different, and we're talking about millions and millions and millions of dollars at stake. Our firm now, Airlie,
Yep.
is in the marketplace for that very reason, because body corporate disputes are complex, they're hard, they are technical. They often need a lawyer, and that makes it good in some respects, makes it difficult in others. I mean, the best example of that, again, your situation, you've put in an application, you've paid your fee and you're hoping for an outcome. The body corporate can draw upon its funds to pay for a lawyer to defend this action. So you've got this imbalance between an unrepresented party who's doing this themselves and the body corporate, which is using funds, which you're paying for as well as part of your levies. There is a disparity there that's very difficult to manage, which is another reason why the Commissioner's Office gives so much assistance to try and address that imbalance. And I have to say, and this is not a dig at lawyers, I do need to say that not every lawyer is as well versed in body corporate law as they could be. It's a very, very specialised area of law. When I was in the chair earlier, we had so many lawyers who were generalists, I'll call them that, who had been picked out of the phone book or Google searches by someone to help them. And you can tell straight away that that's the case, because they have not grasped any of the concepts. They haven't grasped anything that they're required to do at law. And my staff would spend 30 to 40 minutes on the phone with them, talking it through. Yeah, that pained me when that happened. Yeah.
Well, it seems like an unfair sort of playing field, doesn't it? It's
Yeah.
Chris, is there for somebody who does want to remain unrepresented, is there a particular tip or trick or suggestion that you would make for them to make their path a little easier?
Gather as much information as you can, and there's a lot of free information out there that you can. But probably the biggest tip that I could give an unrepresented party is that your job is to convince someone who doesn't know you from a bar of soap that you have a genuine issue, number one, and that number two, what you are seeking is justified. So in effect, you have to put yourself in somebody else's shoes, somebody who just does not know you at all. So you can't rely upon assumptions. You can't rely upon, think of the castle, the vibe of the thing. The vibe of the thing will not fly. I mean, the vibe of the thing doesn't fly anywhere, but the vibe of the thing definitely doesn't fly in this jurisdiction. You have to painstakingly go through it line by line, and good way of doing it, if you're maintaining that you're not going to spend money on a lawyer, get somebody else to read it once you've finished and see if they understand it as a story. If they understand it as a story, chances are you're doing okay. If they've got a bunch of questions, I don't understand this, what happened here, there's something missing in this part, chances are that'll be the same answer in the Commissioner's Office, and you will not pass go. You'll be back to square one.
Yep. So if I was to go back to a day in the life of Chris Irons as the Commissioner, what would that look like?
So usually it would begin, I was usually the first person in the office, and that's just a personal thing, so I could sit, take a deep breath, compose, and sort of prepare for the day. I'd look at all of the incoming corro from the day before or the night before. There's usually a fair bit that comes in overnight. And what that does, why I did that, it just prepped me for any blow-ups that would occur that day or that week. So if I could see through emails and correspondence that things were getting a bit heated in a particular matter, exchanges, whatever, I could then go and speak to some of the team and say, look, what's happening here? We might just need to damp this one down. Or in some cases, I could even say to my team, that's not appropriate. We're not dealing with that. We don't have to take that. And then invariably after that, I would get the new application. So all new applications came to me in the first instance, and I would just have a look just to know what was going on. Sometimes early I would have a look and be with a view to seeing who was involved, and some reasonably, well, not reasonably, some very high profile people had matters in my office, very, very well-known people. Not that they're not entitled to that, but I needed to know just in case there was a problem later on. And invariably we'd start off the day with a bit of a catch up. What did everybody have on? And then a lot of the time it was a mix of things. No one day was the same as the other. Some days it might be in the office with various team meetings. Some days I would be out of the office for several days on the road doing a workshop or a webinar or a seminar or a bit of a function. And then invariably by around late afternoon, that's usually when the action would start to happen. That's when things would start to get produced. And Fridays were typically the busy day in that office. So it was always working towards pushing stuff out the door on a Friday in a lot of cases. I guess that's consistent with law to some extent, Airlie, law firms?
I think that's very consistent, maybe with law firms, but also with any other type of business. There tends to be a Friday or an end of month push to get some things done. It's not uncommon. Chris, now that you've on the outside, so to speak, what would you think could be done within the Commissioner's office, or what should happen within the office?
More money, better resourced. Yep. But apart from that, one thing that was always my big bugbear early was the ability to declare somebody vexatious. The Commissioner does not have that ability as it currently stands. We had what I would call frequent flyers, and I'm sure they're still there now, who would bombard the Commissioner's office with demands, requests, applications. For very little money and sometimes for free, depending upon the circumstances. And my staff would have to action them like they would everything else. And the amount of time and money that we would expend, that body corporate would have to expend defending, or if it was an owner, is huge. And I think there is definitely scope for the Commissioner to have some sort of power to limit, or at least consider limiting someone's ability to access those services. Because at the moment, for example, this is a Queensland-based office and a function of the Queensland government, but if you live interstate or overseas, you have every right to utilise that service as much as Queensland resident, so long as you are an owner. I'm not sure how I feel about that as well. That's a bit, but back to so that's one issue, it's a separate issue, but the vexatious one, yeah, the ability for the Commissioner to be able to say, listen, you need to seek my approval in future if you want to put in an application to my office. A difficult one.
How would you actually go about doing that?
I don't know, actually. It needs a bit more thought. The Commissioner would be in the position of having to actually look at something and determine if it was frivolous on the face of it. A bit of a red flag for that sort of thing, Airlie, would be if somebody put in an application and said that one of their outcomes was an apology. For example, that sort of thing tends to suggest that somebody is off on a misguided tangent. But it's a difficult one. Probably the other thing, if it were up to me, is that the fees would be raised to a level that was commensurate with how much it cost to provide that service. So make people pay for the service they're getting. Again, difficult because lots of people don't have a lot of money in some cases. That would be another thing I would like.
What was the relationship with managers like?
Body corporate managers?
Yeah.
Good, really good, actually. The vast majority of body corporate managers, very professional, and we had a lot of respect, a lot of time, a lot of mutual engagement with each other. I did a lot of work going out to meet managers and talk to managers. they hold such a vital role in a body corporate that I took the view that if we focus a bit of time, or if I focused a bit of time and attention upon them, that would actually be to our benefit in the long run. I think we actually got there early to a certain extent. Yeah, it's always difficult, but I think we saw over time managers paying more and more respect to the functions of that office, and also feeling confident in its outcomes and its consistency. Yeah, so really good. Not every manager, but the vast majority of managers. We have a couple of questions, and we're almost at, gosh, time flew today, didn't it? Question from Bob. Bob, I know you've watched before, thank you. So Bob saying his experience, Commissioner favours lot owners as compared to committees. I've heard that too, Bob, but I also heard the reverse. The Commissioner favoured committees over lot owners. I also heard Commissioner favoured managers over lot owners. I also heard Commissioner favoured caretakers. I once got called Airlie a pro-pet commissioner because my office was known for allowing pets to stay on the scheme. And
that
Bob,
has nothing to do with you having a pet, Chris.
Nothing at all whatsoever.
No.
And Bob, your next question, what other avenue if someone if commissioner declined to take action? Commissioner's office is exclusive jurisdiction, and what that means is if you've got a body corporate dispute in Queensland, you've got no other choice. It has to go through that office. So if the commissioner rejects or refuses, there are some review rights, but that's pretty much it. You basically would have to start again, go through the process again, try and resolve it, go on the steps again. We might almost have enough for a part 2 on this sort of stuff.
I think we might have enough for part 2. I feel like I've only just started. I've actually got some other questions and perhaps some that might be a little more curly, but we haven't quite got
curly is good. Curly is good.
Curly is good.
Let's make save those. Yeah, absolutely. Airlie, thank you. It was a pleasure.
It's very enjoyable, Chris.
Yeah.
For me, and
thank you. Yeah, I think so. Thank you again, everybody, for tuning in. Again, don't forget to like and share. The video will be up on our page for you to watch at your leisure. Don't forget to fire us in a question to info@hineslegal.com.au. If you think that you've got a query and you're not sure about it, fire it through. We'll talk it out and see if we can offer you something to assist. For now, though, thanks, everyone. Thanks, Airlie.
Thanks, Chris. See you, everyone.
See you all next week. Bye-bye.
Bye.